Want to know the latest XRP news? What important statement did the head of the SEC make? If you want to find out, then watch this video to the end and like it. Ripple Labs continues to battle the Securities and Exchange Commission, and their most recent filing is no different, as they immediately respond to the SEC's letter of supplemental authority over the regulator's motion for summary judgment with a confident and forceful rebuttal. The U.S. Securities and Exchange Commission, SEC, recently referenced to a separate enforcement action against investment advice company Commonwealth Equity Services to support its case in the continuing legal struggle between the SEC and Ripple Labs. However, Ripple's legal team has replied quickly, claiming that the reference decision has no bearing on their fair notice position. The SEC's complaint against Ripple Labs, SEC v. Ripple Labs in et al., claims that the business and two of its executives, Brad Garlinghouse and Chris Larson, raised more than $1.03 billion in an unregistered continuing digital asset securities offering. One of Ripple's key claims is that the SEC did not give enough notice before to bringing the securities fraud action in December 2020. The SEC wrote to the judge presiding over the matter on April 11, highlighting the Commonwealth finding, which ruled that a long-established court precedent provides enough fair notice. The SEC stated that the precedent that led to the formulation of the Howey test provided Ripple Labs with ample notice of what defines a security. The SEC also claimed that their case against Commonwealth gives them more power to invalidate Ripple's fair notice position. However, on April 13, Ripple's legal team submitted a response contending that the Commonwealth decision reference does not offer further justification for dismissing their fair notice position. The letter to District Judge Annalisa Torres highlighted the contrast between the two instances. Ripple's defense emphasized the Commonwealth case's lack of contemporaneous evidence, whereas Ripple's situation involves abundant evidence, including communications from the SEC to third parties, demonstrating that reasonable market participants did not regard Ripple's offers and sales of XRP as investment contracts. Furthermore, Ripple's statement stressed that the key question in their lawsuit is whether the Securities Act applies to their XRP offers and sales. The legal team contended that the SEC's reference to an unbroken chain of district court decisions rejecting fair notice defenses is irrelevant since the court had already rejected the SEC's reliance on such instances. Ripple's defense argued that the closest case, Upton, is binding precedent, and that it found in favor of the defendant's fair notice claim, encouraging the court to do the same. The SEC has been fighting Ripple in court for over 2 years on charges that the blockchain startup marketed and sold unregistered securities in the form of XRP. The SEC maintains that the major blockchain business violated securities laws via its XRP sales and is requesting that the court issue summary judgment in its favor. Yesterday, at a congressional hearing before the House Financial Services Committee, SEC Chair Gary Gensler addressed a number of questions on recent developments in the cryptocurrency market. One of the most critical concerns posed to the SEC was whether he considers XRP to be a security. One of the most important questions posed to the SEC chairman was by Congressman Warren Davidson, who questioned whether he feels XRP is a security. Surprisingly, the SEC chairman hesitated to answer the question with a yes or no. Instead, the SEC chairman said that the topic of whether XRP is a security is now in court, and that there are ongoing conversations on the subject. We're in court, and there's active discussion and litigation on that, Gensler said. Notably, Gensler also failed to explain whether Ethereum, ETH, is a security or not. Many cryptocurrency fans were shocked by his reaction, considering that the SEC chairman has maintained that XRP is a security. Last year, Gensler said that Bitcoin is the only cryptocurrency he views to be outside of the SEC's authority. Many believe Gensler unsuited to reign over the agency's activities due to his harsh enforcement attitude in the financial markets, particularly the crypto industry. Interestingly, Congressman Warren Davidson expressed the same idea when he filed legislation calling for the SEC to be restructured and Gensler to be fired. Chairman Gensler Your record of failures to protect investors and abuses of power make it clear that we need to restructure the Securities and Exchange Commission, Davidson said. After outlining some of Gensler's SEC failings and abuses, Congressman Davidson offered legislation to remedy these abuses by asking for the SEC chairman's ouster. To correct a long series of abuses, I'm introducing legislation that removes the chairman of the Securities and Exchange Commission and replaces the role with an executive director who reports to the board, where all authority would reside. Davidson said, "It's worth noting that Judge Annalisa Torres has yet to decide on the Ripple vs. SEC case. Ripple may benefit from the planned legislation to remove Gensler, with Congress shining a light on Gensler's failures and excesses. Judge Torres will almost certainly be under pressure to rule in favor of Ripple." The SEC and Ripple have exchanged documents on one of Ripple's most significant arguments against allegations that it improperly issued unregistered securities in connection with XRP. Ripple, which is fighting the SEC's effort to have the case adjudicated in its favor via summary judgment, is hoping to rely on the fair notice argument. Under U.S. law, a defendant may have an affirmative defense to charges of breaking the law if they can show they did not have reasonable notice that their behavior violated the law, which Ripple claims applies to their XRP offering. However, several recent court judgments concerning the reasonable notice defense imply that it would not apply in Ripple's case. The SEC called the court's attention this week to the most recent of these. SEC versus Commonwealth Equity Serves LC, decided last month and in which the court rejected a fair notice argument made on the identical grounds as Ripple. It specifically ruled that the defendant could not use the fair notice argument since the SEC's accusations were based on a 50-year-old Supreme Court decision. This was true, even though according to the defendant, the SECs had been aware of the improper activity for more than 2 decades. The SEC had been aware of the improper activity for more than 2 decades. In other words, the SEC's reluctance to enforce regulations in the past does not justify violations of same rules in the present. Given that the SEC's argument is similarly founded on decades-old Supreme Court precedent, the Howey test for assessing whether an offering amounts to an investment contract and so constitutes a securities offering, these SECs contended that the court should reach the same result. Ripple responded quickly, informing the court in a document that the Commonwealth case could not be used since the defendants adduced no contemporaneous evidence supporting its defense that market participants lacked fair notice. This, according to Ripple, is in contrast to its own argument, which it claims includes abundant evidence showing reasonable market participants did not think the offer and sale of XRP constituted a securities offering. It further contended that the court in Upton, on which Commonwealth is based, found in favor of the defendant's fair notice argument and that the court in this instance should do the same. According to the judge, Upton was an effort by the SEC to discipline the CFO of a brokerage business for breaching in SEC regulation that established the formula for calculating how much brokerages must keep in a client reserve account. The fair notice argument may apply since the SEC's punishments were based on a unique interpretation of an existing regulation that had not been made public. Instead, the SEC has based its claim on a straightforward application of a venerable Supreme Court precedent that has been applied by hundreds of federal courts across the country over more than 70 years, noted the judge in Elbry. While this is the first time it has been utilized against a digital token issuer that did not hold an ICO, Elbry is in no position to argue that it did not have fair notice that its conduct was illegal.